spanning the globe on many interesting topics. But today, or this morning, we start in the Middle East, North Africa region. And just as an initial note before I introduce our moderator, this conference was founded by Jose Antonio and myself in the desire of creating a forum that really reflects the incredibly diverse and globe-spanning nature of international arbitration now. And the arbitration world has grown dramatically in the last 20 some odd years or even less. And I think the nature of this panel in itself is a great example of how fantastic and experienced arbitration practitioners exist all over the world, not just in the major centers that we all typically know where arbitrations have tended to be centered, but now we see arbitrations in every corner of the globe. And our conference is making an effort to reflect that dimension of the world we work in. And apropos to that, this session being on the Middle East, North Africa, we have Megan Bachman, who is a partner at Kroll & Mooring, along with me. I welcome Megan to the panel today. She very kindly agreed to moderate this topic, which she is incredibly well suited to do. She actually came to Kroll & Mooring about a year ago with a great group of lawyers with a practice focused in Doha, Qatar. And that practice involves international disputes involving major infrastructure. The firm has worked for years with the government there, and in particular, the latest project has been on the Hamad Airport, and many other matters as well. So we have the firm has a great interest in the region. We've worked on many cases, as have I, in Kuwait and Egypt and elsewhere. And this is really a great way to kick off the day. And we'll pass it over to Megan for what I know will be a great panel and a great discussion. So there you go, Megan, and enjoy.
Thank you so much, Ian. I am delighted that you are all joining us for today's World Arbitration Update panel, focusing on the Middle East and North Africa region. I think it's fair to say that from an arbitral perspective, the MENA region is of particular interest for any number of reasons. Given the prevalence of infrastructure development and construction projects in the Middle East and North Africa, there has been a rise in disputes associated with the region, many of them mega disputes that match the scale and value of the mega projects underlying them. And for the majority of construction disputes in the Middle East, international arbitration remains the resolution process of choice. The MENA region is also an extremely dynamic one. The last decade alone has seen immense change and in some areas volatility and continuing conflict. In some countries, there's been wholesale regime change, sometimes multiple regime changes, and developments to the systems of government. And there have been multiple reshufflings of regional alliances, and these shifting political and legal landscapes have themselves given rise to disputes, as well as set the stage for commercial and investment disputes. The MENA region has also long been a crossroad of the world, historically as the link between Asia, Europe, and Africa, and in more recent times, a nexus of energy, trade, religion, culture, and travel, among other things. Many arbitrations of MENA-related disputes reflect a convergence of legal systems and principles from the local civil law that applies to the parties' rights and obligations, Shariah law principles, local procedural law, and in many cases also common law perspectives and approaches of project participants and investors in the region. All of these features in turn feed a variety of nuances surrounding arbitration of disputes in MENA, which brings us to today's panel, the title of which is Middle East North Africa Region, Mega Disputes, Expansion of International arbitration centers and a renewed interest in Sharia law as a foundation of applicable law. I have the immense privilege of introducing to you today our speakers for today's panel, all of whom are stars in the field, have particular expertise in the nuances of arbitration in the MENA region, and whose accomplishments are too extensive to allow me to capture more than just a fraction of them in my introductions today. I'm going to introduce your speakers in the order in which they will appear. Today's presenter is Munia Aharte Alonso. Munia specializes in international commercial and investment arbitration. She is a PhD candidate and lecturer in international arbitration at the Universidad Complutense de Madrid. She obtained her LLM from Georgetown University Law Center and also a master from the Université Paris 1 Pantheon-Sorbonne. Prior to turning her focus to international arbitration, Munia gained experience in multilateral diplomacy as an advisor to the European Union delegation to the United Nations, and she also trained at the Spanish Permanent Representation to the European Union, assisting with the Transatlantic Trade Investment Partnership and Comprehensive Economic Trade Agreement negotiations at the European Council. Munia is also a frequent contributor to the Kluwer Arbitration blog. We then have our three panelists. Our first panelist is Shireen Foti, a senior associate at Covington and Burlington in Washington, D.C. Shireen focuses her practice in international commercial and investor state arbitration and has particular experience in the energy sector, regularly representing clients in gas pricing arbitrations under long-term gas supply agreements. Shireen earned her Bachelor of Arts from the University of Michigan and a Juris Doctorate at the George Washington University Law School. She was also a Fulbright Fellow in France and has an LLM in French and European law. Shireen has for several years been a leader within Arbitral Women, and she currently serves as a member of the Board of Directors, and before that was a board liaison and steering committee member for the Young Arbitral Women Practitioners. In addition to Arbitral Women, Shireen serves on the steering committees of CPR's YADR, the Campaign for Greener Arbitrations, and is the advisor for diversity and inclusion for arbitrator intelligence. Shireen has deservedly been recognized as the best lawyers one to watch for France in the field of international arbitration. Next, we will have Sarah Colilat Aranjo. Sarah is a partner at the El Tamimi and Company law firm in Dubai. Her practice crosses the spectrum of complex commercial disputes, with particular focus on cases involving corporate and commercial matters, banking and financial law, and property and construction disputes, including particularly energy-related projects, both in arbitrations and also arbitration-related court proceedings. Sarah earned her LLB from St. Joseph University and has a master's in international business law, another master's in strategic management and finance, and an LLM from Harvard Law School. Sarah is also a member of the Board of Directors of Arbitral Women and serves as well on the Board of Directors of the Paris MENA Legal Club. She's also an adjunct professor of law at the Université Paris 2 Pantheon-Assas and a member of the ICC Commission on Arbitration and ADR and its task force on arbitration and ADR. She was recently appointed as an expert to the DIFC Courts Arbitration Division Working Group. Sarah also has been recognized by Who's Who Legal and was the 2019 recipient of the Middle East Rising Star Lawyer of the Year Award. And last but not least by any stretch, we are honored to have Professor Dr. Mohammed Abdel-Wahab joining us today as well. Professor Dr. Abdel-Wahab is a founding partner and head of the International Arbitration Construction Energy Group of Zulfikar and Partners in Cairo, Egypt. Professor Dr. Abdel-Wahab earned his law degree from Cairo University, where he now serves as the chair of the Private International Law Department and professor of international arbitration and English law. He's earned postgraduate degrees in private law and international law. And following these, Professor Dr. Abdel-Wahab earned a Master of Philosophy and a PhD from Manchester University, as well as an advanced diploma in international commercial arbitration from Oxford University. Professor Dr. Abdel-Wahab has served as an arbitrator, legal expert, or counsel in well over 230 arbitration cases, including particularly complex, high-value institutional and ad hoc arbitral proceedings involving parties from the world over. He has appeared as an arbitrator, counsel, and legal expert in cases under the auspices of essentially every arbitral forum in the MENA region, as well as ICC, ICSID, LCIA, SEC cases, and multiple ad hoc UNCITRAL proceedings. Professor Dr. Abdel Wahab is recognized as a world-leading arbitrator and arbitration practitioner on international investment and international commercial arbitration, construction, energy, and infrastructure disputes, as well as particularly Egyptian, Arab, and African laws, Islamic Shariah, and private international law. In addition to his arbitration practice and professorship, Professor Dr. Abdel Wahab has just recently been appointed to the Institute for Transnational Arbitration Academic Council, and also serves as the chair of the International Expert Committee of the Permanent Forum of China Construction Law, and from 2015 to 2021 has been the vice president of the ICC International Court of Arbitration. Since its inception, Professor Dr. Abdel Wahab has been featured in Who's Who Legal Thought Leaders in International Arbitration, and was most recently recognized in Who's Who's Global Elite Thought Leaders. There's one other piece of Professor Doctor's history that I'd like to highlight here, which is before the rest of the world went virtual as a result of the global pandemic, Professor Dr. Abdel Wahab was at the vanguard of online dispute resolution issues. He is a world-renowned authority on ODR and is co-editor of the leading 2012 treatise, Online Dispute Resolution Theory and Practice, of which I understand a new edition is forthcoming. He's also the co-editor of International Arbitration and the COVID-19 Revolution, and is the author of the Abdel Wahab Pandemic Pathway to Virtual Hearings. I could go on and on about Professor Dr. Abdel Wahab and each one of our speakers, but suffice it to say that the team at the World Arbitration Update has put together an amazing group of true leaders in the field of arbitration generally, and particularly on matters pertaining to arbitration in the Middle East. Before I turn it over to you, Munia, as a presenter, and then to the panelists, I just wanted to share a few points about today's format, which is we have an hour and a half reserved for today's session. Each of our speakers are aiming to spend about 10 or so minutes on their remarks, with the goal of reserving plenty of time at the end of the panel for discussion and the opportunity to respond to questions from you. So if you have questions as we go, please do post them in the chat, as we can return to them at the end and may even be able to get to some of them during the course of the panel. And then in the last 15 minutes of the session, we'll have the opportunity to go into small breakout rooms to meet one another and have smaller format discussions there. So I encourage you all to please stay for what is sure to be a further lively discussion in the breakout rooms. And just as one last reminder, please be sure to stay on mute to avoid inadvertently interrupting any of our speakers. Thank you so much. And with that, I'll turn it over to you, Munia.
Thank you, Megan, for singing our praises so eloquently. Thank you to the organizers, Jose Antonio and Ian, for the invitation of the first edition of the WOW, the first of many to come. And thank you to the stellar panelists that joined us today. As to my presentation, it serves the purpose of presenting the panel's topics and a broader outlook on the region, leaving substantive aspects to panelists. At the outset, this panel will focus on, as I said, substantive, but also procedural aspects of disputes involving either MENA parties or MENA jurisdiction. This is not yet another construction or debt talk. It is a much deeper and rich discussion. And citing Karim Youssef, there is a quest for cosmopolitan law in MENA. And this quest is framing our topic for today, which is MENA as a hotspot for international dispute resolution, shedding a new light on its relevance, and we hope debunking certain preconceived ideas as to the challenges arbitration in the region may convey. The World Arbitration Update will provide an update on latest trends. However, allow me to put this into context. MENA counts with historic landmark cases from Petroleum Development versus Sheikh of Abu Dhabi to Aminol versus Kuwait in the 80s, that shaped energy arbitration, as well as the paradigmatic case Salini versus Morocco in 2001, aka Salini test. More recently, a decade ago, the Arab Spring triggered a series of political events in the late 2010s, which was a catalyst for numerous cases. Shireen will update us on the claims and defenses that arose out of the Arab Spring with ramifications up until today. As to the latest institutional developments in the region, last month, inter alia, the Memorandum of Understanding between the ICC and the Union of Arab Banks was signed, aiming to promote the culture of arbitration and ADR across Arab banks and financial institutions in the region. As you all know, in 2019, the ICC expanded its presence in Abu Dhabi with its 5th case management office. And those developments support the conceptual framework that was laid out by the ICC workstream on arbitration of Islamic finance disputes, which produced a 2019 report I invite you all to read on the development of a comprehensive Lex Islamica and procedures for Islamic finance, which encourage the use of arbitration in resolving Islamic finance disputes. And this was assessed in light of the Shariah's doctrinal diversity. Beyond the harmonization of Lex Islamica, courts have been supportive of the arbitral process, both in the mechanism of interim measures in several MENA jurisdictions, Sara El-Koleilat will discuss, and as well as the latest enforcement decisions stemming from the Cour de Cassation in Egypt will be presented by Professor Dr. Mohamed Abdelwahab, which are in line with an arbitration-friendly trend. I'm hereby referencing the 27 October 2020 judgment that recognized inter alia that virtual hearings are consistent with Egyptian law without going as far as adopting arbitration as an autonomous legal order. This decision confirms, citing Professor Dr. Abdelwahab, the leading edge of the Egyptian judiciary, and I may extrapolate this to other jurisdictions you will hear about today within the MENA region, Africa, and beyond. And I give the floor to Shireen Fati.
Thank you very much, Munya, and good morning and good day to everyone who's participating today. May I ask the organizers to please open my set of slides for this presentation. Thank you very much. So today I will be discussing the invocation of Arab Spring events in recent international arbitration claims and defenses. This is a topic which I've been interested in for some time and have been following eagerly, particularly looking at how the events, the factual events of the Arab Spring have had an impact upon the types of arguments and defenses which are being raised in international arbitration cases. If you could please go to the next slide, what we can see is that the number of newly filed ICSID cases, so now looking only at ICSID, against Arab state respondents has risen sharply in the years following the Arab Spring. So from 2011 to 2021, there has been a dramatic increase in the number of cases which have been presented. Since 2011, the average number of newly filed cases with Arab state respondents has been in the order of around 5 per year, with some years, having a quite larger amount of cases. For example, in 2013 and 2017, we saw 8 new cases, and in 2018, 9 new cases. Although the number has slightly tapered off in the more recent years, which may suggest that we're reaching a point of resolution of many of these claims. However, let us pose the question as to whether this may change now with a whole set of new COVID claims, which may arise in future years. So still in 2020 and 2021, Arab state respondents represented 9% of ICSID's new caseload, with 4 and 5 cases respectively, still representing quite a large number there. And of the ICSID caseload for new cases, On average, cases against Arab respondent states represented about 12%. So of the entirety of the new cases each year, a significant portion of those were being brought against Arab respondent states. So if you could please go to the next slide. If we break that down by country, we can see that certain countries have been more frequently on the receiving end, and I'm sure Professor Dr. Abdul Wahab can testify to those. The most frequent respondent state being Egypt, who has seen 26 cases since 2011. If you look at each year, they are by far the most frequent respondent state, which has been targeted by claims relating to or arising out of the Arab Spring, but also other topics. We also see Algeria has been a frequent respondent, Libya also more recently, Morocco, Iraq, Saudi Arabia, Jordan, and other states as well. If you go to the next slide, please. I had a look at the sample of cases, a sample of cases brought by against the Arab states under various institutional rules. So looking at not only ICSID cases in this circumstance, but also ICC, PCA, ad hoc proceedings, to try to assess what were the particular trends that we can see within this field. And what I was able to learn is that a number of cases, a large number of cases, were discontinued or settled during this time period. So you see that gray peak on the left side of the screen. There, particularly with the state of Egypt, there were quite a large number of cases which were either dismissed or settled of the total number which were brought against the state of Egypt. So in total, 28 cases were dismissed or settled. Another 23 were decided in favor of the state, and 14 cases were decided in favor of the investor. We can see that Libya is a frequent unsuccessful respondent state, but Egypt has actually fared pretty well, with 8 cases decided in favor of the state and 17 discontinued or settled. So this may be an indication that because of the robust arbitration regime in Egypt, because of the Egyptian State Lawsuit Authority, which is the state mechanism or the state office which handles all disputes coming in where the state is named as a respondent, perhaps the state successfully deals with many of these cases which are coming in, which from, depending on the disposition of the position you're representing, could either be claimed as being, brought perhaps without merit or without kind of any basis for the claims, but simply as a starting point for perhaps negotiations or discussions behind the scenes. But it seems that Egypt has actually done pretty well at handling those. So the outcomes have not always been favorable for investors. Some cases have been dismissed on jurisdictional grounds. Others have resulted in liability decisions in favor of the respondent state. But there are certainly some which have been successful, meritorious claims which have succeeded at the international arbitration level, award stage, I should say. So now moving on to the next slide, I do want to quickly give a few examples, and we can maybe go further in depth in this discussion when we get to the discussion period. I wanted to raise a few of the examples of what are we seeing as certain arguments and defenses which arise out of the facts coming from the Arab Spring. So of the greater sample of cases I looked at, only some of them have directly dealt with the Arab Spring. Some have mentioned it in passing without necessarily relying on the facts which have been presented as a basis for any of their claims or defenses, perhaps in an attempt to color or contextualize the claims which are being made. Or the defenses which are being brought by a state against the claims being brought. So some of the cases against respondent states, both in the investment and the commercial context, have examined select events of the Arab Spring uprisings, which have been raised by both claimants and respondents alike to support their positions. The first one we can look at is the necessity defense. And I won't go through every single case here, but I did want to pull out a couple of interesting examples, which might trigger some of the discussion later on. So, for example, in the Union Fenosa Ixid case, a Spanish gas company brought a case against Egypt. The respondent state Egypt invoked, amongst other arguments, the doctrine of necessity under customary international law to defend against its shutting down of an LNG plant. And it claimed that its prioritization of supplying natural gas to feed domestic electricity in Egypt, rather than exporting that gas, as had been agreed initially under the contract with the investor, was an act of necessity, which was the only way to maintain Egypt's security, public order, stability, safeguard its essential interests, and maintain its basic services in the face of grave and imminent peril. So it was raised. It was unfortunately, I'm sorry, I have a visitor here this morning, so excuse me. So in the, so in that case, the tribunal actually dismissed the necessity defense. So the defense of necessity was found to be unfounded and could not excuse respondents' failure to comply with its obligations under the Egypt-Spain Treaty, though the state would not be viewed as having contributed to the state of necessity unless it subjectively intended to create that situation. So it's an interesting example of attempted use of the necessity defense and then it unsuccessfully being invoked. In the Strabag versus Libya case, there was another instance where it was attempted to be used, and it was not reasonably possible for the Libyan authorities to invoke this argument. So if we can look now to the second, the next slide, the second example, seeking to break the causal link. So in another case, Olin versus Libya, this was a ICC case brought by a Cyprus investor, which was seeking compensation for Libya's alleged expropriation of the land in which it had invested in order to build a dairy and juice factory. And there, Libya argued that the element of causation, so here from the state's perspective and the state's defense, Libya was arguing that the element of causation was missing from the investor's case and asserted, amongst other arguments, that the harm that it may have suffered in the post-February 2011 time period was the result of the chaos arising out of the Libyan revolution and not from acts attributable to the Libyan state. But the tribunal in that case, in its award, was unconvinced by that line of argument. And it held that while the events of the Libyan revolution and civil war may have had a general impact on the investment climate post-2011 and may have contributed to the underperformance of the Cyprus investors' business, those events would not be sufficient to address the investors' underperformance prior to 2011. So when compared to the other market entrants around the same time period as that Cyprus investor, another competitor with similar initial investments at the outset of its investment in 2006 was able to make large profits in a short time period and maintain its position as a market leader despite the events of the Libyan crisis. So comparing to other investors, the tribunal was able to say, well, the events that you invoked in the relating to the Arab Spring, they may well have colored the circumstances, but they didn't have a requisite impact on the element of causation that you were seeking to apply. If we go to the next slide, and please, Megan, cut me off if I'm going over time, but I do want to just very quickly touch upon these last couple of examples.
No, I think it's important that you do touch on the last few slides, so please go ahead.
Thank you. So Example number 3 is the case of force majeure. So where force majeure is actually being invoked by a claimant as opposed to a respondent. So an example of that is the Gujarat versus Yemen case. And in that case, an ICC case, a group of Indian investors sued the Yemeni state and one of its ministries, seeking, among other claims, declaratory relief that an event of force majeure continuing for 6 months existed, and that the contracts in question were therefore validly terminated. The tribunal in that case recalled in its award that as of January 2011, the security situation in Yemen had begun to deteriorate, with increased instances of tribal clashes, attacks, kidnappings, and other problematic events, which led up to the declaration of a state of emergency by the government in 2011. And the tribunal stated that a number of such events had occurred on multiple occasions and in various locations between 2011 and 2013, which were beyond the reasonable control of the claimants. The 3 claimants in that case suggested that those events fell within the definition of force majeure contained in the contracts, and they relied upon the clause in question to send a notice to the respondent state, automatically suspending its obligations under the contracts. A further contractual clause provided that if the force majeure situation would continue for a period of 6 months, the claimants would have the option to terminate their contractual obligations. And the tribunal agreed with the claimants there that an event of force majeure did indeed exist and continued for that period of 6 months, and that as such, the claimants had validly terminated the contract. So there we see the invocation of difficult circumstances surrounding the war in Yemen, the state of emergency being invoked by the claimants as a justification for invoking the force majeure clauses within the contracts as a basis for valid termination. There it was successful in that case. Similarly, in the General Dynamics case, the civil commotion, unrest, and riots in Libya also constituted force majeure, even though there was no official notice provided to the state. So there we, and sorry if we can just skip to the next slide very, very quickly. The state right to improve workers' wages. Here we're talking about kind of a social or public policy interest that was invoked, and the tribunal dismissed in this case claimants' allegations that a change in the relevant labor law caused the damage to its investment. So this was an interesting turn on this type of invocation. And then very lastly, example number 5, corruption and fraud. We've seen this most recently in the Neural versus Libya case, which just was the annulment proceedings decision was just handed down before the Paris Court of Appeal recently, stating that the corruption allegations of the partial in opposition to the partial award on jurisdiction pertain to the merits, and that no breach of public policy could be found at this jurisdictional stage. So I think I'll stop there. It remains to be seen how tribunals will indeed continue with this, with their analysis of these types of cases and facts, and how they will look at attempts by both states and investors alike to have the events of the Arab Spring and political and social uprisings taken into account in their cases. But there's certainly more decisions which are forthcoming, and we will see how those will be decided. We can certainly discuss what some of the trends are and what commonalities we can see in the discussion period. So thank you for indulging me with this slightly longer time period.
No, thank you, Shireen. And I think it'll be helpful maybe even when we come back to the discussion time. I'd love to hear a little bit more as well about force majeure cases arising out of the Arab Spring, because clearly that is something that we've seen more of in the last year and a half as well in relation to COVID-19. And I'm interested in your views as to sort of the precedent that's been developed in MENA around force majeure from the Arab Spring cases, and how that might apply going forward on the next wave of COVID cases. Sarah, I'll turn it over to you.
Thank you very much, Megan. And good morning, good afternoon, or good evening for our participants today. I'm very delighted to be here with you today. And once again, thank you very much for the organizers on the Herculean efforts in putting this first edition of wow, it's wonderful to be with everyone here today. And I'll be covering, as indicated by Megan at the outset of this talk, interim measures in the context of MENA arbitrations. And as many of you know for sure, interim measures, which are often also referred to as provisional or conservatory measures, or even protective measures under certain legislations, are measures which typically take the form of an order or even an award aimed at protecting parties' interest before or during the pendency of arbitral proceedings. And so historically as well, if we look at the jurisdiction as well as the availability of interim measures, historically, these would have been within the ambit of the powers of the national courts. And over sort of the last 3 decades, there has been obviously a movement towards providing further powers and authorities to arbitral tribunals. And as we will see today, we are definitely in this trend here in the MENA region. And maybe just to quote, with respect to the relevance or importance of interim measures, I would just like to quote a very telling passage from the ICC Secretariat's Guide to Arbitration. And I quote that interim or conservatory relief can be an important, if not essential tool for protecting the legitimate interests during an arbitration. And so since today we're talking about mega disputes, and we are definitely in the region, just to echo what Munya said at the outset of today's talk, we are definitely in a very interesting configuration here in the MENA region. Most economies here are emerging. And when one talks about emerging economies, then one definitely talks about projects. And obviously one subset of projects is obviously infrastructure and construction. And we typically often say here that the MENA region is predominantly a construction/infrastructure arbitration-driven region. And because that is the case, then any practitioner would often have to consider the ultimate protection of interests, which could arise and often in situations before commencement of arbitration proceedings, or sometimes as well during the course of arbitration proceedings as well. And so just in a nutshell, interim measures, when we look at the several arbitration laws in the regions, and as many of you may know here today on today's discussion, is that the availability of interim measures is often embedded in the lex arbitri, or the procedural law governing the framework of an arbitration, as well as complemented with respect to institutional arbitration under the institutional arbitration rules that the parties have agreed to apply. And often most, internationally, globally recognized arbitration institutional rules often provide and bestow on arbitral tribunals the power to order interim measures. And often we find it as well in the region from a practical perspective. Parties tend to also expressly agree on certain authorities granted with respect to certain courts with regards to the availability and powers to order interim measures. However, I think there is one important feature as well, I guess, with respect to MENA arbitrations, is that we often find as well a dichotomy in a way between the theory, which on one hand, if we look at the main arbitration laws of the region, of the major seats in the MENA region, we definitely have express provisions, and we've seen such a trend over the past 10 years with respect to express powers to equally national courts, but also arbitral tribunals to be able to order interim measures. And I could, for example, provide the example of the 2018 federal law on arbitration in the UAE, Law number 6 of 2018, which has expressly provided powers to the court, but also to the arbitral tribunal as well, to order interim measures. And I'm referring particularly to Articles 18 and 21 of the federal law on arbitration in the United Arab Emirates. And what's also interesting is that in a push even towards further protection of assets in the course of any arbitration, the UAE law of arbitration as well even provides the arbitral tribunal with the power even to be able to go on itself, on its own volition, in addition to the parties, to be able to request for an interim measure. And I think what would be really interesting as well, maybe for some of our colleagues who join us today on the call, who may not necessarily be very familiar with the region, is also echoing Munia's observation, is that the region itself, in addition to the cultural richness that we have in the region, we also find it reflected with respect to the legal traditions that are applied in the region. We obviously have a region which is predominantly civil law governed and enshrined from civil law legal tradition. But we also have had obviously certain jurisdictions which have been predominantly inspired by Sharia law, or even certain jurisdictions, and I'm referring particularly to Saudi Arabia, where Sharia law is actually the main guiding principle or framework for the judicial system in Saudi. Other jurisdictions, for example, such as the United Arab Emirates, use Sharia principle by way of guidance. And then you would add a third layer to that, is if you look at the United Arab Emirates and if you look at the state of Qatar, you would have a hybrid model. And the hybrid model results in having common law jurisdictions, and those are typically referred to as judicial enclaves of common law laws, but also courts. And I'm referring particularly to three main jurisdictions, which are the DIFC, so the Dubai International Financial Center, the Abu Dhabi Global Market in Abu Dhabi, and the Qatar Financial Center courts, the QFC courts in Doha in the state of Qatar. And those three separate jurisdictions as well, which I appreciate can be a little bit surprising at the outset for colleagues from outside the regions, but those standalone jurisdictions enjoy regulations, laws, including regulations on arbitrations and a dedicated standalone arbitration framework, which also expressly provides for powers for arbitral tribunals to also order interim measures, but also under certain circumstances for the national courts to be ordering certain interim measures in protection of mainly assets in the course of dependency or even before arbitration proceedings. And I'll touch upon certain nuances there. And so ultimately, we have an interplay at different levels in the MENA region. On one hand, we could be ending up with a jurisdiction which is purely Sharia governed, a jurisdiction which could adopt, a hybrid mode, or we could end up with a third type of jurisdiction, which is going to be predominantly a civil law jurisdiction. And while, like I said, most new recent arbitration frameworks in the region, and I'm talking about modern arbitration in the MENA region, I'm not talking about the 18th century or the 19th century. And Munya mentioned as well the very famous Abu Dhabi award back in the 50s of the last century. But I'm talking really about modern arbitration in the MENA region, which I think more or less we can pin it down to the last probably 10 to 12 years. And this is when we started seeing a trend with having jurisdictions here and states enact new arbitration laws. And part of that movement is, just to put it into perspective, was aimed at actually providing a safe framework for foreign investors who were not probably necessarily very interested in litigating any disputes before the national courts. So The recent arbitration laws, and I'm talking about the Bahraini arbitration law of 2015, which pretty much refers to the UNCITRAL model law, the ADGM regulations of 2015, the DIFC arbitration law, which dates from 2008 and which has been amended slightly in 2013, and the Saudi arbitration law of 2012 with the implementing regulations in 2017. And we've seen very recently the much awaited arbitration law at the federal level in the UAE, which goes back to June 2018. And all of these laws, as I've said, they provide for express powers with certain nuances for equally national courts and arbitral tribunals to issue and award interim relief. And this leads obviously to the practical challenge, which is often found, which goes up to the issue of concurrent jurisdiction. And the concurrent jurisdiction notion with respect to interim relief is even much more interesting to look at in the context of MENA disputes. Because technically speaking, concurrent jurisdiction, the concept of concurrent jurisdiction typically goes back to the issue of concurrent or competing jurisdictions between, on one hand, the national courts, and then on the other hand, the arbitral tribunal. Whereas in the MENA region, and I'm referring specifically to those jurisdictions with a hybrid model, particularly the United Arab Emirates and the state of Qatar, well, we have an added value of concurrent jurisdiction because we actually end up with a competing jurisdiction within, on one hand, the civil courts, and then on the other hand, common law courts. And if time permits, I will gladly share with you one practical experience I've had, which has resulted in a convoluted battle between the parties, between several fora within the same jurisdiction.
Yes, Sarah, I'm really glad that you mentioned that because I was hoping that in your last minute or two, you would actually touch on what's the practical effect here. Is there a tension or is there a battle? So please do share that with us.
Thanks, Megan. And so what I really wanted to maybe close out on, and maybe I'll give those practical examples, is that for the past 20 years or so, there has always been an issue with regards to, on one hand, bridging the gap between what the theory said, which has been necessarily providing support for either a prospective arbitration or an ongoing arbitration, which historically has lied with the courts. But more recently, with the advent of the new legislative regimes, the arbitral tribunals did indeed have powers. And I can share with you, for example, that under most modern arbitration rules, there is the provision and tool which is for the EA, the emergency arbitrator. However, historically, there has been a dichotomy in practice because while on one hand, we had a theoretical framework which afforded certain powers, enforceability, and I know that Dr. Mohammed today will talk about enforceability, but from a final award perspective, the gap had always remained that the enforceability of interim orders, particularly tribunal-ordered interim orders, were often challenging and were often not secured, which sort of inhibited the aim of, from the outset, obtaining interim relief. However, in 2016, there was a DIFC court judgment, the multiplex case, which has also confirmed, on one hand, the availability and recognized availability of onshore interim ordered relief in the context of DIFC court proceedings. Very recently, about 2 years ago, and it's a case I was involved in as well, there was a case in which an arbitral tribunal that had issued an interim relief in an ongoing DIFC seated case that was actually issued for enforcement by the DIFC courts. And there's the famous 2018 case in which the Cairo Court of Appeal, it's the Dusan versus Damietta Port famous dispute in which the Cairo Court of Appeal actually ordered for enforcement at an arbitral tribunal issued interim relief. And all of that to say, and I conclude by this, is that we are definitely seeing a positive trend in the MENA region where there has been broader powers given obviously to arbitral tribunals and also by the same token, the relevant support by the courts, obviously not all courts, but the relevant support given by the courts, particularly with respect to the enforcement of arbitral tribunal ordered interim measures.
That's a perfect transition, Sarah. The relevant support is a perfect transition to Professor Dr. Abdel Wahab's remarks. So with that, we'll turn it over to you.
I'm very grateful to have been invited to be part of that event, and I'm very grateful to Megan for her very kind introduction, which I'm sure has not done much justice to my esteemed speakers, but has certainly exceeded what I deserve at my end. Now, of course, the benefit of speaking last after great, highly intellectual and very capable speakers is that I can simply say I concur. And fortunately, we have allocated different topics. So I will try to match their wits and intellect in the coming 10 minutes or so. The difficulty I'm in is that I need to discuss with you about 5 decisions, 2 legislative amendments, and an interesting piece of information or statistics from a notable MENA jurisdiction. I will endeavor to do so in the next few minutes. Now, I've been entrusted with addressing new developments regarding recognition and enforcement in the MENA region. It is a very interesting region, quite volatile, and there are always new developments to report on. And that makes it all the more interesting and worthy and quite attractive and appealing to people across the globe. Let me start with some very simple developments that would be known to many of you, but will have greater, I would say, implications and developments to report on perhaps over the next year. And that would be Iraq joining the New York Convention as the 168th, perhaps 169th, depending on how you see it, with the later states that have joined, including Belize. They ratified the New York Convention on the 4th of March, 2021, and deposited their instrument of ratification in May 2021. Now, that signals a very new development, given that Iraq now is a jurisdiction that I would say at the forefront of arbitration developments, given the involvement of a number of Iraqi parties in international arbitrations. So stay tuned as to how the Iraqi courts, which to my understanding have not yet had an opportunity to address this new development, are going to apply the New York Convention when it comes to recognition and enforcement of awards. Moving a little bit to the south from Iraq, and that's to the United Arab Emirates, which is always a very interesting jurisdiction. And all my great panelists have addressed developments in many jurisdictions, including the UAE, and I speak under the control of Sarah there, who is a guiding marker on the developments in the UAE. But I will say that there are 2 interesting developments that are worthy of reporting, one of which may be known to many, the other I doubt, and that could be quite interesting to report on. On the 14th of June 2020, and that, as you know, follows the enactment of the UAE Federal Arbitration Law number 6 of 2018, a judgment by the Dubai Court of Cassation referring to all pages of arbitral awards have to be signed. There's always been a matter of controversy whether you should sign all pages of the award or not, and out of abundance of caution, normally people would initial all the pages and sign the last page, and that would qualify as signing all pages of the award. But there are instances where the award has only been signed on the last page, or I should be more precise, on the pages of the dispositive section, which could go to 2 to 3 pages or even more, depending on what the dispositive covers. Now, on the 14th of June, the court says that even though that the arbitration law article 41(3) of the federal arbitration law only refers to signing the award, the court said that all pages ought to be signed. Now, that is a new development, and people are now proceeding with signing all the pages out of abundance of caution in that sense. But it is much hoped that in the future, this strict requirement, let me say judicial requirement, it is certainly not expressed in legislation as every page, could hopefully be relaxed a little bit. Now, the more interesting development comes on the 9th of June, 2021, from the Dubai Court of Cassation decision. And this time, it's not just a judgment, it's a decision by the General Committee of the Court of Cassation. So these are 10 judges. They're not just deciding a case, they're simply laying out the practice of the court, let's say judicial custom of the court that will be applied. And that relates to legal and delay interest. Now, those who are familiar with arbitration in the UAE know that the cap would normally be 12% and the judicial custom would be in the range of 9%. The court has reduced that and said that they are now changing the judicial custom to be that the interest rate would be capped at 5% as the judicial custom per annum, rather than 9%. So that is a development that tribunals sitting in the region and applying UAE law should be aware of. Now, moving a little bit now to the West and goes to Egypt now, my very home jurisdiction, and I've noted with great appreciation the input from Munia, Shireen, and Sarah, bits and pieces there to report from Egypt. We've had some interesting developments. And these interesting developments that I will discuss relate to 3 particular decisions by the Court of Cassation and 1 legislative amendment relating to the Supreme Constitutional Court's law. Now, the decision that Munia has kindly referred to in her excellent opening that set the stage for all of us is basically the 27th of October 2020 decision by the Court of Cassation, which is really a forward-looking decision addressing a number of topics. Now, that decision, 4 main principles were highlighted. Estoppel, venire contra factum proprium, as known to many, has been captured by the court. It is a long-standing principle. It is not legislatively expressed, by the way, in Egyptian law. Unlike the UAE law, for example, where Article 70 of the Civil Transactions Law specifically refers to estoppel. In Egypt, the first one was actually, long ago in the 1950s, the Court of Cassation did refer to estoppel in a non-arbitration context. Then the first time in an arbitration context was the Court of Appeal 2013. And in 2020, the Court of Cassation actually spelled it out in the context of arbitration, saying that estoppel is a general principle of law that also applies in the context of arbitration. It also added the also well-known principle of no party may benefit from its own wrongdoing, and settled a long-standing saga about party representation, that party could be represented by counsel that may or may not be lawyers, and if lawyers, they don't need to be registered with the Egyptian Bar Association. So that pretty much opens arbitration in Egypt as a good seat for arbitration, with foreign counsel prosecuting cases without any fear or concern about their status. And then finally, the reference to virtual hearings, which I can only say I concur with what Munia said, that this is not inconsistent with Egyptian law. Obviously, it is a case-dependent or a case-sensitive exercise, but the Supreme Court just signaled the possibility that virtual hearings are, again, a global development that are not inconsistent with Egyptian law. Now, moving to 2021, on the 24th of June, 2021, there was the Court of Cassation judgment in the infamous case of Kharafi versus Libya. Now, that is quite an interesting case because it's an investment arbitral award rendered under the auspices of the Unified Agreement for Investment of Arab Capital in the Arab States. Quite interestingly, over the past 7 or 8 years, we've had a saga where we got an arbitral award, 3 decisions by the Cairo Court of Appeal, and 3 decisions by the Court of Cassation dealing with that arbitral award. It is quite interesting, and I know the timing. I may have about 4 or 5 minutes left, but in time, I will say that this was about a $936 million award plus interest at the rate of 4%, rendered against the state of Libya under the treaty. Libyan state applied to set aside the award before the Cairo court, the seat being Egypt. This was rendered under a treaty that does not envisage an appeal of an arbitral award, and there is an express provision referring to the finality. In that sense, what has happened is that the Court of Appeal said, we do not have jurisdiction under that treaty to deal with this award. The Court of Cassation said no. It went back to the Court of Appeal. The Court of Appeal said for a second time, and quite surprisingly, no, we're not reviewing it again. It went back to the Court of Cassation. The Court of Cassation said, no, you are going to review it, and we have jurisdiction. And that was remanded then to a different circuit of the Court of Appeal. The Court of Appeal a third time said, well, the arbitral award is against public policy. You want us to review it? We did that, and it is against public policy, emphasizing cultural public policy. The reason being is that there is a disproportionality in the quantum granted by the tribunal in that sense. Proportionality being expressed that the harm and the loss should be proportionate to the damages awarded. And they said this is a principle of public policy and it is set aside. Now, many people have expected this to be the end of it. I thought it would not be, and it turned out not to be the case. The Court of Cassation, for a third time, despite inviting the Court of Appeal previously to do their job by reviewing the award, well, said, yes, you did review it, but you got it wrong. And they reversed the Court of Appeal decision and said the award stands because it goes beyond the four corners of the principle of public policy. You cannot simply review an award on the merits, and this assessment of damages is reserved for the tribunal and cannot be reconsidered by a court of law. So it set the principle that arbitral awards cannot be subject to a de novo review on the merits, and that there is no ground to apply the principle of public policy. And by that, on the 24th of June 2021, the Court of Cassation ended the saga of the Kharafi versus Libya dispute. And then on the 8th of July, the Egyptian Court of Cassation again rendered a judgment in the DEPCO versus DPA ICC award. And the importance of that, it is the first ever ICC arbitral award to be set aside by Egyptian courts. We can go into that during perhaps the discussion, and I can shed light on the reasons. The Court of Appeal, it suffices to say that the Court of Appeal, the Cairo Court of Appeal, said the award stands and there is no reason to set it aside. The Court of Cassation differed and said it is to be set aside on the basis of public policy because decisions by administrative authorities, administrative decrees in a way, are not arbitrable, and so it is against public policy to enforce that award. It is a decision that is subject to controversy. Some people agree, others disagree with the decision, but it is definitely worthy of consideration to report on this development. The final development relates to the Supreme Constitutional Court law amendment on the 15th of August 2021 by virtue of Law 137 of 2021, amending the 1979 law of the Supreme Court of Cassation. Now that no longer has a direct relevance to arbitration, but why am I addressing it? For two reasons. People to know of this, to be aware of that legislative development. It deals with the right of the Supreme Constitutional Court of Egypt to deal with the enforceability within Egypt of decisions by international organizations, and a request to deny enforcement of foreign court judgments rendered abroad against the Egyptian state, in that sense, if enforcement is sought in Egypt. Initially, the third limb of the law included reference to the possible review of arbitral awards by the Supreme Constitutional Court, an added layer that was not previously there. In the final version that is published in the official gazette, arbitral awards do not feature and they have been eliminated. So everyone should be comfortable now that arbitral awards are not subject to review other than the review basis in the arbitration law of Egypt number 27 of 1994. The final development comes a little bit from the east, and that's from the Kingdom of Saudi Arabia, which is a jurisdiction on watch to many. because of the great developments and the strides they are taking to enforce the awards. And I second what Sarah has mentioned. Over the past decade, legislative developments in the MENA laws have led to a more arbitration friendliness towards enforceability. And that started in the Kingdom of Saudi Arabia with the enactment of the 2012 law regarding arbitration. The interesting thing to develop is that in February 2021, the Ministry of Justice of Saudi Arabia announced that they have received since 2016 no less than 25,000 enforcement applications. And that accounts for about 4.7 billion Saudi riyals at stake. Imagine the great potential that jurisdiction has and the number of enforcement applications that they have experienced. 8,964 of these applications took place only in 2020, and a fair percentage related to foreign awards. So that is a jurisdiction to watch. I expect that there will be further developments as the Saudi courts open up more and more to the enforceability of awards. I'm afraid, given the time limit I have, I will stop there. And I'm very grateful for your patience, but I'm looking forward to a discussion. And I thank very much my co-panelists for their excellent presentations. Megan, the floor is yours. Thank you.
Thank you so much. That was very informative. I have a question first for you, Shireen, from the chat, and that is, and also after Shireen, after you answer it, please, I would invite the rest of the panelists, if you have further thoughts, to please do jump in. Have tribunals hearing MENA region cases been more receptive to claimants' invocation of Arab Spring justifications as force majeure than of the respondent states? Do you see a difference in how they're treating the claimants and the respondents as far as force majeure?
That's a good question. I think that of the few cases that I did identify where respondents were invoking force majeure as a justification for in defense of their position in a particular arbitration, I don't believe that any have been successful, if I'm not mistaken. But I will have to look back through the list. The ones that I have seen at least discussed in great depth have been those where the claimants are invoking it as a basis for getting out of the contract, of their contractual obligations. And it's interesting to think about that in the context of COVID, you know, as we have seen in the cases which I mentioned earlier, there are quite a lot of times in which we are seeing a party invoke force majeure in the context of, you know, the events surrounding the Arab Spring, the factual events, as a justification for saying, well, you know, the contextual situation was so grave, so serious that you cannot envision your commercial operations or your investment operating within a framework completely and entirely free of that context. You have to understand that certainly in the assessment of the facts and in the performance of the relevant contract or the execution of the investment, it is sure, I mean, at least in my practice, I've seen that COVID finds its way into, you know, in the more recent submissions which have been made, COVID finds its way into almost all of them in some contexts, whether it be an actual invocation of force majeure or some sort of excuse or necessity or some disposition which is seeking to invoke, you know, non-application of the contractual terms or of the performance of the investment in the preferred context. So I think that with the Arab Spring and with COVID now, we see those names and terms thrown around quite readily. But what I sought to do really with this research was to see, well, what actual impact is that having on the claims and defenses that are raised? And I think the conclusion can be that they don't have such an enormous impact as one would think. Their successful impact has been rather limited, and only in rare instances have tribunals really found that they are sufficient to find in favor or against the party's position. You have to really bring a showing of of impact upon a claim or defense, you cannot simply put something in the context. But of course, parties will use these events to color and to contextualize their claims and defenses. So I'm not sure if that entirely answers the question, but hopefully like shed some light on what we're seeing, I guess, in the jurisprudence.
Yeah, it does. And I think it's quite interesting too that everybody in the world has a level of empathy right now for the impacts of COVID. And so perhaps, at least on first blush, there may be more reception, a better reception to COVID-related force majeure claims in these cases, but perhaps not. In the long run, the matrix is still the same, as you say. You really do have to show an impact. I have a question from the audience as well for you, Mohammed. In the Al-Kharafi case, do you think the last Court of Appeal went too far in reviewing the merits of the award? And if so, why did it review the merits of the award, considering that Egyptian courts are generally reluctant to do so?
Thank you very much, Megan. Thank you for the question. I must say it's an excellent question, and to do justice to the decision and to be objective in assessing it, I would say the following. Personally, I think the decision went far, but I will have to say the following. The court, let's say the circuit, and the judge who rendered that decision is an arbitration-friendly judge. He's one of those few who support arbitration and who has been at the forefront of, for example, saying that interest rates do not pertain to public policy, something that the Court of Cassation has not yet picked up. So he's really pro-arbitration. The thing is, and in fairness, he looked at the award and looked at the expert evidence. And I'm quoting from the award, he said, hundreds and thousands of pages of expert evidence on calculating compensation based on assumptions that from his perspective or from the court's perspective were quite like building a straw house or straw man, and felt that it was quite disproportionate. And the position was that the case started with a request for relief in compensation for about $5 million. Then it moved up to tens of millions. Then it became 936. From the court's perspective, that signaled a claim that was not meritorious. And so the line that they have actually crossed was that the principle that damages would be awarded to compensate a loss is a principle of public policy. But what they did is they took a leap of faith to consider proportionality. And so that is where they crossed the line and would have then be seen as looking into the merits. So I do appreciate and understand the perception that motivated the court to render such a decision, but I'm afraid that actually it is a review of the merits, which is not authorized. And that is why the Court of Cassation said, no, you can't conduct a de novo review of the merits. And if the arbitrators have awarded compensation that others may see as unwarranted or exaggerated, the position is that this is the party's choice to go to arbitration and choose those, select those arbitrators. So that was the end of it. And so you cannot then second guess what the arbitrators have done. I hope I've answered the question, and I feel that the Court of Cassation is correct in its final decision in the Kharafi versus Libya. But I'm afraid I personally think that under the treaty, national courts do not have generally a right to review awards in a sense. But that anyway is now settled because the court made the arbitral award stand and is back on the table.
Thank you. I know that we're about to move into the breakout rooms, but if I could get the indulgence of the panel for just 1 or 2 more minutes, I wanted to pick up on something that you just said, Professor Doctor, which is that this Court of Appeals decision was rendered by an arbitration-friendly judge, actually. And I would love to hear from any and all of the four of you on what you're seeing with trends in sort of the experience of the local judiciary in the MENA region with enforcement of arbitration orders and awards. Sarah, why don't you start?
Yeah, definitely, I think there's a trend towards more favoritism or arbitrary favoritism in the region. And as I said earlier, this has been fueled by considerations of attracting further FDI in the region. I would have to also maybe caveat this to say that this trend is not to be overgeneralized, right? There are certain outliers, I would say, as well in the region. The trend is there, but I wouldn't say it has yet become superbly well established. And I would like maybe to give out an example for our participants today is, for example, issues of capacity and authority to agree or to consent to arbitration proceedings. This is a prevailing feature of arbitrating in the MENA region, whereby there are often challenges to the validity itself of the arbitration agreement on issues of consent or authority matters at the time the parties have entered into the arbitration agreement. And while we've seen really a trend towards safeguarding arbitration agreements at the VIFC courts, for example, because standard applicable there would sort of apply the doctrines of apparent authority. Such a trend has not been necessarily applicable regionally at the courts, civil courts level. However, we've seen a trend now over the past 5-6 years before the Dubai courts, and I'm referring particularly to the Dubai Court of Cassation, which has actually, and quite interestingly, used an Islamic law principle, and I'm referring to the equivalent, and Dr. Abdul Wahab mentioned that equivalent earlier on, which is the civil law equivalent of the doctrine of estoppel. And if we look at Article 70 of the Civil Code, it pretty much says that one should not be permitted to benefit from a conduct to which it has sort of conducted and should not actually renege on such a conduct. And interestingly enough, the Dubai Court of Cassation has been using such a principle, which is a Sharia principle, an Islamic law principle, to also try and safeguard the validity of arbitration agreements on the basis of the doctrine of good faith as well. I have to caveat that this trend is not yet to be considered as a jurisprudence constante. There has been conflicting also decisions. And more importantly, the trend is only now for the time being limited to Dubai, to the Emirate of Dubai. Other Emirates have not followed through yet. So just in a nutshell, the trend is quite positive. It will take time, obviously. Two sort of ancillary developments is that the DIFC courts have established an arbitration working division and are leaning more and more towards having a specialized arbitration circuit within the DIFC jurisdiction, which obviously is very welcome. And maybe just Megan on the point that Shireen mentioned earlier with regards to COVID and the impact of COVID, there was a similar decision by the Saudi Supreme Court as the one that Professor Abdul Wahab mentioned with respect to interest by the same sort of body or equivalent body, which is the General Assembly of the court back in December 2020, which has had really an impact from a substantive level on arbitrations as well in Saudi particularly. And it pretty much provided guidance, which pretty much is interesting, again, stems from principle of Sharia, which that in view of achieving justice under certain conditions, obviously, COVID is to be treated as a force majeure exonerating liability, or as an emergency situation, paving the way for the readjustment of the obligation. And this is obviously a very important and determinative decision that has also been, I guess, the highlight over the past 10 to 12 months here.
Thank you so much, Sarah. That's That's just fantastic. Very informative. I want to make sure that we do save time for our breakout. So I think at this point we will move into breakout rooms. And as I said before, we can certainly continue the conversation there as well. And I look forward to it. And I want to just thank again our fantastic presenter, Munia, and our amazing panelists. So Jose Antonio, do you want to lead us into the breakout room? Oops,
Megan, we thank you for your very capable moderation, in all honesty. And I speak, I think, for myself and all my co-panelists. We are delighted that you moderated us. Apologies for cutting you, Jose, but I think our thanks were due.
Yes, thank you. Thank you so much.
And Mr. Muhammad, we concur.
Thank you so much to each one of you. It was, I sincerely believe that I'm not exaggerating. It was really a stellar panel. Thank you to each one of you. I will not repeat your names, but we are immensely grateful from start to finish. Before we go into breakout rooms, we had a promise to also share thanks to our sponsors, and I must give a good piece of thankfulness to Charles River Associates, NERA, Compass, and also our various circle of firms, including E&A Law, CMS, King and Spalding, Claviger Law Group, Sufi Carr, and partners, Sidley Austin, Ramon International, Mintz Group, Alex Partners, Nivalian, Validity, and Statera. Now, we'll move into the breakout rooms, and hopefully you'll enjoy. Do enjoy the time with the stars, and thank you very much.